Hello and welcome back to our channel. The world is constantly changing, and numerous significant events are unfolding globally. Today we're diving deep into some startling developments within the United States immigration system. Millions of individuals residing in the U.S. could soon face the daunting reality of being compelled to leave, irrespective of their personal desires. Why is this happening? What seismic shifts are occurring so rapidly that entire communities might vanish practically overnight? The landscape of immigration is being redrawn before our very eyes, impacting countless lives. Stick with us as we unpack these critical changes. We understand these topics can be complex and impactful. We strive to provide accurate and valuable information for educational purposes. The content reflects a collection of viewpoints and insights gathered from various sources, including articles, social media, public forums, and news sites. We don't claim absolute accuracy and encourage viewers to conduct their own research using multiple trusted sources. Our aim is not to target or discredit any individual, organization, or nation, but to encourage thoughtful reflection on current events. Please watch with an open mind. Your support is crucial for us to continue delivering this kind of analysis. Please consider liking this video, subscribing to our channel, and hitting the notification bell. Let us know in the comments where you're watching from. We love hearing from our global audience. New immigration regulations are making it significantly more challenging than ever before to legally remain in America. Families who have built their lives here over many years could find themselves uprooted tomorrow. Even individuals possessing legal protections are not entirely secure. Could you potentially be affected by these changes? Is the very fabric of your city on the verge of irreversible transformation? The situation is evolving quickly, and the next rule change might impact you more directly than you realize. From abrupt deportations to policies specifically targeting large groups, the ground is shifting beneath the feet of many residents. These aren't just abstract legal changes. They represent potential upheaval for families and communities across the nation. The uncertainty is palpable, creating an environment where stability feels increasingly fragile. We'll delve into the specifics of these policies and explore their far-reaching implications. Remember to watch until the very end, where we'll summarize our key findings and offer concluding thoughts. Something truly significant has just altered the landscape for immigrants in the United States, and if you fall into this category, this information is vital. Imagine waking up one morning to discover that, effective immediately, you must continuously prove your legal right to reside in the country. This isn't a hypothetical scenario. It's the reality introduced by new regulations. There are no excuses and no exceptions to this requirement. Does this sound extreme? Perhaps, but it is indeed happening. The mandatory migrant registration rule, a pivotal change, now mandates that all non-citizens register with the federal government. This isn't a simple administrative task. It involves providing sensitive biometric data, such as fingerprints and facial recognition information. Furthermore, individuals must carry proof of this registration at all times and report periodically to designated immigration offices. The regularity and nature of these check-ins add another layer of scrutiny and potential stress to the lives of non-citizens. The stakes are incredibly high. Failure to comply with any aspect of this registration process isn't met with a mere warning. It could lead to immediate detention, right on the spot, without recourse. This stringent enforcement underscores the seriousness with which the government is approaching this new mandate. The implications are vast and touch upon fundamental questions of privacy, surveillance, and the rights of individuals within the nation's borders. It represents a significant shift towards stricter monitoring of the non-citizen population residing within the U.S. The reach of this mandatory migrant registration extends far beyond just undocumented immigrants, challenging common assumptions about who is affected. Guess what? This rule isn't confined to those without legal status. Even individuals who hold valid work permits or are in the process of seeking asylum, with pending cases, could encounter substantial hurdles. These are people who, under previous frameworks, might have felt a degree of security in their status while navigating the legal system. Now, they too are subject to these demanding registration requirements. The constant need to prove their right to stay, provide biometric data, and report regularly adds layers of complexity and anxiety to their already challenging situations. Could this be the initial move towards larger-scale deportations? The question looms large. What occurs if someone, perhaps through simple oversight or misfortune, forgets their registration documents at home? Or if they miss a reporting appointment due to unforeseen circumstances? The consequences could be immediate detention. With over 46 million immigrants currently living in the U.S., this single rule has the potential to destabilize entire communities almost instantly. Neighborhoods built over generations, enriched by diverse cultures and contributions, could find their social fabric torn apart as residents face uncertainty and the threat of removal. The ripple effects on local economies, schools, and social structures could be profound and long-lasting, reshaping the demographic and cultural makeup of regions across the country. Let's examine the enhanced deportation policy concerning alleged gang members. You might reasonably assume that the justice system would necessitate solid, irrefutable proof before an individual is arrested or deported, especially for something as serious as gang affiliation. That's the bedrock principle of due process, right? However, under this new aggressive rule, the standard of proof has shifted dramatically. Guess what? You no longer need a criminal conviction to be expelled from the country under this policy. The mere suspicion of gang involvement is now sufficient grounds for authorities to initiate removal proceedings. Even if an individual has never been charged with, let alone convicted of, a crime, association, or alleged affiliation can trigger deportation. This policy is currently in full swing, and it's fundamentally altering the dynamics of immigration enforcement. Authorities possess the power to deport anyone suspected of gang ties, bypassing the traditional requirement of a criminal conviction. Imagine the potential for error or misuse when suspicion alone becomes the threshold. Some individuals apprehended under this policy are reportedly being held in detention facilities like Guantanamo Bay before being shipped off to countries they haven't seen in years, sometimes decades. Think this policy only impacts actual criminals? Think again. The criteria for suspicion can be broad. If you've ever been in the wrong place at the wrong time, associated with certain individuals, or even misunderstood due to cultural or language barriers, you could potentially be caught in this wide net. A simple misunderstanding could cost you everything: your home, your family, your life in the U.S. With over 10,000 deportations based on alleged gang affiliation already reported, this crackdown isn't just targeting confirmed gang members. It's casting a shadow of fear over entire neighborhoods and communities, where association can be easily misinterpreted or misrepresented, leading to devastating consequences for innocent individuals. The termination of temporary protected status, or TPS, for Venezuelans marks another significant and concerning shift in U.S. immigration policy. Imagine living legally in the United States for years, meticulously following all the rules, building a life, raising a family, contributing to your community, only to abruptly wake up one morning and discover that your legal permission to stay has vanished. You're no longer welcome. There's no advance warning, no transition plan provided, just a ticking clock counting down until you are forced to leave the country you now call home. Does this sound like a terrifying nightmare? Unfortunately, for approximately 300,000 Venezuelans residing in the U.S., this nightmare has just become their stark reality. The termination of TPS for Venezuelans is now officially in effect. This program was initially designed to offer a safe haven for individuals unable to return safely to their home countries due to ongoing armed conflict, environmental disasters, or other extraordinary and temporary conditions. Venezuela, facing profound economic collapse, political instability, and widespread humanitarian crisis, was designated for TPS, offering protection to its nationals already in the U.S. Many of these Venezuelans didn't just choose to leave their homeland. They were forced to flee a country in utter chaos, seeking refuge and stability. The U.S. government itself recognized the dire situation by granting them TPS, acknowledging it as a necessary form of humanitarian relief. But now, that crucial protection has been revoked. There are no extensions being offered, no avenues for appeal presented, just the cold, hard reality. Get out or risk deportation. Deportations are already underway, adding urgency and fear to an already vulnerable population. And here's where the situation becomes even more heartbreakingly complex. Guess what? A significant number of these individuals have American-born children, U.S. citizens by birthright. They own homes, have established businesses, pay taxes, and are deeply integrated into the fabric of American communities. They are neighbors, colleagues, and friends. Yet, overnight, they have been reclassified, stripped of their legal status, and effectively turned into undocumented immigrants with only one grim option: leave voluntarily or face forced removal. Think about the devastating impact this has. If a government can unilaterally strip legal protections from one group, previously deemed worthy of humanitarian consideration, who could be next? Could this establish a dangerous precedent for other TPS recipients from nations like Haiti or El Salvador, countries also facing significant challenges? With hundreds of thousands now scrambling for dwindling options, facing the prospect of returning to a homeland still in crisis, or living in the shadows in the U.S., this isn't merely an immigration issue. It is a humanitarian crisis unfolding in real time, raising profound ethical questions about the nation's commitment to those seeking refuge and the stability of families deeply rooted in American society. Consider the enactment of the Laken Riley Act, a piece of legislation that further intensifies the current immigration enforcement climate. You'd typically think that if arrested in America, the principles of justice would grant you, at the very least, your day in court before facing severe repercussions like indefinite detention or deportation. Isn't due process a cornerstone of the system? But guess what? Under this newly enacted policy, that fundamental assumption is challenged. The Laken Riley Act, signed into law effective January 29, 2025, stands as one of the most stringent immigration laws witnessed in recent years. It mandates the detention of undocumented immigrants who are merely accused of committing certain crimes, including offenses related to theft. This signifies a major shift. An accusation, not necessarily a conviction, can trigger mandatory detention. This means no possibility of bail, no second chances considered, and potentially no thorough consideration of the individual's specific circumstances or ties to the community before detention is imposed. If you are undocumented and find yourself arrested under suspicion of one of these specified offenses, your fate is practically sealed. Detention is mandatory pending removal proceedings. But the implications don't stop there. Here's the real kicker. The Laken Riley Act also empowers state attorneys general to sue the federal government directly. This legal avenue is available if they believe federal immigration laws are not being enforced with sufficient harshness within their state borders. This provision effectively grants states a direct pathway to pressure federal agencies like ICE into adopting more aggressive deportation tactics and increasing enforcement actions. This creates a potential patchwork of enforcement levels across the country, driven by state-level political pressures rather than a uniform federal standard. And don't mistakenly believe this law only targets individuals accused of serious, violent crimes. The legislation is drafted broadly enough that someone caught shoplifting, or even driving without a valid license, could potentially end up detained indefinitely and fast-tracked for deportation. No conviction is necessary. The accusation alone is enough. With thousands already being detained under these stricter new rules, even before the Laken Riley Act fully takes effect, families are being torn apart, sometimes over relatively minor offenses. What happens when innocent individuals get caught up in this system due to false accusations or misunderstandings? The potential for injustice is significant, raising serious questions about the balance between enforcement and fundamental rights in the current immigration landscape. Let's turn our attention to the revocation of humanitarian parole programs. Imagine finally arriving in the United States after a perilous journey, perhaps fleeing violence or persecution, believing you've reached a safe harbor. Your family's safety, your very future, hinges on this new beginning. You've been granted temporary entry through a humanitarian parole program, a vital lifeline in a world fraught with uncertainty, offering a chance to rebuild. But what if that lifeline, that promise of temporary safety, was suddenly and arbitrarily ripped away without any warning. That's precisely the situation unfolding now, due to the revocation of several key humanitarian parole programs. This policy change strikes at the heart of programs designed to offer temporary refuge to individuals facing urgent humanitarian crises or significant public benefit cases. It affects programs that have historically provided pathways for individuals from countries like Cuba, Haiti, Nicaragua, and Venezuela, allowing them entry while they pursue more permanent immigration solutions. This abrupt policy shift impacts over 200,000 refugees and asylum seekers who had already been granted this temporary relief. These weren't individuals attempting to circumvent the system. They were admitted legally, often after extensive vetting, under programs specifically created to address humanitarian concerns. Guess what? The government has essentially pulled the plug on these programs, leaving beneficiaries in a state of limbo, their temporary status revoked. These individuals, who escaped life-threatening situations, now face the terrifying prospect of being sent back to war zones, back to political persecution, back to regions where their lives are in immediate danger. Why is this reversal happening? The administration argues that these parole programs have been exploited, with individuals overstaying their authorized period or entering with fraudulent claims, straining national resources and undermining the integrity of the immigration system. While there might be instances of misuse, is it justifiable to revoke protections wholesale, affecting thousands of innocent people who have complied with the rules and desperately need safety? Critics argue this revocation disproportionately harms vulnerable populations, effectively punishing those who followed the prescribed legal pathways. These individuals, many of whom have waited years, sometimes decades, enduring unimaginable hardships for their chance to enter the U.S., are now told their dreams of safety might be out of reach. The human toll is immense, impacting not just the parolees, but also their families and the communities that welcomed them. Could this signal a broader retreat from humanitarian protections? Could it set a precedent for dismantling other pathways for those seeking refuge? The deportation of over 20,000 individuals previously under these programs is already in progress, intensifying the crisis and leaving many to scramble for options where few exist. The potential end of birthright citizenship represents perhaps the most profound and constitutionally significant change being discussed. What if one of the most fundamental rights in America, the right enshrined in the 14th Amendment, granting citizenship to nearly all individuals born on U.S. soil, was suddenly challenged or eliminated? The idea that simply being born here automatically makes you a citizen has been a cornerstone of American identity for over a century and a half. Sounds impossible to change, right? Yet under the proposed end of birthright citizenship policy, this long-standing principle could become a reality for millions of children born in the U.S. to non-citizen parents. This policy aims to reinterpret or amend the 14th Amendment to exclude children born to parents who are not U.S. citizens or lawful permanent residents at the time of birth. You'd be shocked to learn the potential scale. Over 4 million children currently living in the U.S., born to immigrant parents, could potentially lose their birthright citizenship status under such a rule, facing uncertain futures in the only country they've ever known. The rationale proponents offer for this drastic move is that birthright citizenship acts as a magnet for illegal immigration, encouraging what they term birth tourism, instances where individuals, often wealthy foreigners, travel to the U.S. specifically to give birth, thereby securing citizenship for their child and potential future immigration benefits for the family. They argue ending it would discourage illegal border crossings and preserve the integrity of citizenship. But is this a fair or constitutional solution? Is it just to penalize innocent children, stripping them of their citizenship based on the immigration status of their parents, circumstances over which they had no control? Here's the twist. This wouldn't just affect children born under questionable circumstances. Even children born in U.S. hospitals, with no connection whatsoever to criminal activity or fraudulent entry, whose parents might be long-term residents working towards legal status, could face having their citizenship questioned or revoked. Critics argue this fundamentally undermines the 14th Amendment and creates a two-tiered system of citizenship, potentially rendering millions stateless or subject to deportation. The legal battles surrounding such a policy would undoubtedly be immense, likely reaching the Supreme Court, challenging over 150 years of legal precedent. Once a policy like this gains traction, hundreds of thousands of families would be forced to reconsider everything: access to health care, education, employment, and their very future in the United States. Could this be the first step toward redefining American citizenship itself, potentially eliminating rights that have been part of the nation's fabric for generations? The implications are staggering, raising deep questions about identity, belonging, and the future direction of the country. The cumulative effect of these policy changes, mandatory registration, enhanced deportations based on suspicion, termination of TPS, the Laken Riley Act's mandatory detention, revocation of humanitarian parole, stricter public charge rules, and the potential end of birthright citizenship, paints a picture of an immigration landscape undergoing a rapid and severe transformation. As promised at the beginning, let's draw some conclusions. Firstly, the threshold for remaining legally in the U.S. is rising significantly, affecting not only undocumented individuals, but also those with various forms of temporary or pending legal status. Secondly, enforcement is becoming more aggressive and preemptive, with detention and deportation possible based on accusations or suspicions rather than solely on criminal convictions. This raises serious due process concerns. Thirdly, humanitarian considerations, once a significant factor in U.S. immigration policy through programs like TPS and parole, appear to be diminishing in importance, potentially leaving vulnerable populations with fewer options for safety. Fourthly, the very definition and accessibility of U.S. citizenship could be fundamentally altered if challenges to birthright citizenship gain further ground. These shifts are creating a pervasive climate of fear and uncertainty within immigrant communities across the nation. Families are facing impossible choices, communities risk losing vital members, and the long-term social and economic consequences are potentially vast and damaging. The debate often centers on national security and resource allocation, but the human cost, the disruption of lives, the separation of families, the denial of refuge to those in desperate need, cannot be ignored. While proponents argue these measures are necessary for border control and maintaining the rule of law, critics contend they are overly harsh, potentially unconstitutional, and betray core American values of welcoming immigrants and offering refuge. The ongoing legal battles and the evolving political climate mean that the situation remains fluid, but the trend towards stricter enforcement and reduced pathways to legal status is clear. It's crucial for everyone, citizens and non-citizens alike, to stay informed about these changes, understand their potential impact, and engage in the ongoing conversation about the future of immigration in the United States. Thank you for watching. Please like, share, and subscribe for more in-depth analysis on critical issues shaping our world. Let us know your thoughts in the comments below.